Hello, Advanced Wealth Strategies family. It is my pleasure to introduce you to Terrence Quinn, attorney at law. Terrence is with the TGQ Law Firm here in Ann Arbor, does a lot of work throughout southeastern Michigan, and we are going to be talking about estate planning in recognition of National Estate Planning Awareness Week this week, and really wanting to make sure that we hit some important items for the year end. Welcome, Terrence.
Thank you so much. I love the work that you all are doing at Advanced Wealth Strategies, always serving people at a high level, and it's my privilege and honor to join you.
Thank you. I'm excited just to get into it. I know you are an incredible presenter. You are constantly creating awareness, holding events virtually, in person, all over the place to explain to people the differences between things like a will and a trust, what probate is. And one of the things that I really appreciate about you is that education piece, because I believe that an educated investor or an educated client is someone that's much more well equipped to be able to handle the stressors of life and the things that are going to come at them. And one common misconception that I hear is that people feel like a will can be enough. And I know there's never a 100% answer in legal or finance at times, but could you start there and tell us a little bit more about what the difference is between a will and a trust, and maybe why someone might want to consider one over the other?
I get one call, I get 1,000 with people saying, "Hey, I just need a simple will. My situation is easy. It's not a whole lot," right? And what they're really saying to me is they don't want to pay a lot of money, right? They assume it costs a lot of money.
Sure.
And so a lot of people do believe a will is enough, and a will can be enough
Sure.
depending on your situation. A will is a wonderful tool. So let me back us up. So when we talk about estate planning, we're talking about the process where you put in writing your answers to two major questions. And I think these are two of the four most important questions ever that we will deal with. What happens to your stuff, your assets, and your children if you pass or when you pass? And what happens to you if you become incapacitated? And the point of estate planning is for you to put in writing your answers to those questions so that you can give us your answers at a time that you can no longer give us those answers. And so the writing is where we find those answers. And one of the ways that you can write that is through a will. So wills they have a bad rep, right? People talk about them like you should never do a will. And I disagree. I understand why people say that, but I disagree. A will is a wonderful tool to list those answers. And if it's done by an attorney who knows what he or she's doing, it will be written in a way, you got to hear this, that presents the least likelihood of a successful challenge to what you wrote in that document. That's the whole point. And so, if you're okay with what a will means, then a will can be a wonderful tool for you. But that's the point. What does a will mean? A will means probate court. Your question was, what's the difference between a will and a trust? Many people have heard of trust. And at a fundamental basic level, the difference between the two is probate court. And so, while yes, you can put your answers to those questions in a will, you're telling those answers to the court when you put them in a will. So a lot of people come to me and say, "I just need a simple will. It's, not a lot." And I ask them, "Okay, no problem. We do simple wills and complex wills. Are you okay with your family going through probate court when you're gone?" And they always say, "No, that's why I'm
Mm-hmm.
calling you. That's why I need
Mm-hmm.
this will." And I tell them, a will is nothing more than a letter to the court telling the court who you want in charge of the case. It used to be called a executor, now it's personal representative, and who gets everything after the time, cost, publicity, and maybe chaos of probate court.
Sure.
If you want your family to stay out of court, the best way, the most efficient way is through a trust. And real quick, that's its purpose, is to keep you at a basic level, to keep your family out of court. There are multiple other reasons for a trust. We can get fancy. We don't have to, but there are multiple other reasons for a trust. But at a basic level, the difference is probate court.
Sure. Well, and having minor children, that can be one perk as a mother of two young children saying, "Hey, I want to have control from the grave. I don't know who these kids will become. Let me put some stipulations on when they can have the money, why they can have the money, and who gives them that money," as an example. Versus if I just had a will, my understanding is everything goes through the court, and at 18 they're just handed the money, no strings. And I don't know about you, but at 18 I wasn't ready for that type of responsibility.
18, I was playing football, running around Ann Arbor, having a good time. And I think I was fairly mature. Don't ask my cousins that, but I think I was fairly mature at that time. But if you had left me $10,000, $100,000, a million or more, I would hope that I would have had a lot to show for it in a year or 10. I don't know how much I would have had though. So, right. And that's the other advantage and benefit of a trust. A trust not only keeps you out of probate court, but also it allows you to distribute assets according to whatever schedule you choose.
Uh-huh.
Now, you can do that through a will, but it's a will that tells the court to create a trust. It's
To
called
do
a
it.
testamentary trust. And to me, it just doesn't, in most cases, make sense to create a document for court that tells the court to create a document that's designed to avoid court. Why not avoid it in the first place by building the trust that stays out of court and then putting those stipulations in the trust that give the assets over time? One other thing with a will, yes, it goes through court. Another problem is, while if you have minor children, you raise the minor children discussion, the court is going to assign somebody to manage that money for that child until they're 18. But at 18, they get it, even with a will. So a trust is where you can say, no, in my case, for example, I have two children. My trust says when I'm gone, if I'm gone while they're young, my sister becomes the trustee. She manages it for them while they're growing up, can cover things of living, health, support, maintenance, and education. HIMSS is the acronym.
Mm-hmm.
Um, and then when they turn a certain age, my trust says they become co-trustee, so they can start learning how to do stuff. But she still makes the decisions, the ultimate decisions. And then at 35, they're fully in the driver's seat and they can do with it what they choose. So when we talk about trust, that's a second benefit of them is it allows you to distribute assets over time with whatever stipulations that are legal that you decide to put in there.
Yeah. And one very important piece to the trust is you cannot just create a trust and avoid probate. So one of the things that's very important and an area that I think that TGQ does a very good job on is ensuring people fund the trust. So providing instructions that say, okay, now that we've created this legal document, here's what you have to do with your bank accounts, your life insurance, your investments, your 401k, letting them know without you directing the assets towards the trust. It's really an empty garage with nothing inside of it. And even though you
That's
have a
right.
lock and a keypad to it, no one cares because there's nothing of value within that.
That's right. And just the fact that you raised that highlights one of the first things that I talk about in the workshops I do. As you know, I do a ton of workshops. And at the beginning now, there's a whole segment where I talk about everybody 18 and up needs a team of three.
Yeah.
And that team of three, I mean, no matter what you own, you should have a team of three. And the very first person on that team is your life insurance agent slash financial advisor, because it's their job to help you build wealth. The accountant is the second to help you watch it and also help build it, but account for it correctly and everything. And then your state planning attorney, of course, I believe should be the captain of the team. And it's their job to coordinate the whole package. And so the point is exactly what you're talking about. With your estate plan, the trust keeps you out of probate court if two things happen. The first is the trust has to be built correctly. If you think of the trust as a big bucket, to me, that's why it's extremely important to make sure that you have a true expert in bucket building build the bucket for you so we can build it in the right kind of way. But the second thing is equally important. While you're alive and able, you want to make sure you properly put your stuff in the bucket or at least connect it to the bucket. And the trick is the second that you're gone, you don't want anything left out of the bucket. If anything is out of the bucket after you're gone, no matter how well I built it, your family's still going to go through probate court, at least with regard to that thing that's not in the bucket. And so this is where I love working with dynamic financial advisors. And I think everybody knows that you are my primary person that I refer to, Aaliyah. And I just tell people, she's great. Believe me, you're going to love her and it's going to be all great. And then they always, I don't want to say this. You don't even know what I'm going to say. And you didn't tell me to say this. I have never had a client call me back and tell me that they did not enjoy working with you. And part of it is because you're so on top of your game, including with funding. And so when you have a fantastic financial advisor and you've created a trust, that advisor doesn't even wait on your attorney to reach out to them about funding. They immediately reach out to you about the funding. And that's exactly what Aaliyah does, what you do all the time, because you know, like I know, that if there's any place that the ball often gets dropped in this probate avoidance story, it's at the funding level. And so you asking that question highlights everything I just said.
Well, and assets change, right? So I think that's where that coordination comes into play, is that you might sell a home, buy a new one, open up a new account. And so the advisor should be watching for those changes to ensure that the bucket stays funded. But also, I would have to say, I think it's important to connect with your estate planning attorney on a regular basis and ensure that you've got that second set of eyes reviewing everything to make sure you didn't go out and open something else and that created an issue, or you didn't go buy a collectible. Or I know we had sent out an email a few months ago about Robin Williams and his memorabilia being something that had a point of contention between the wife and the kids. And, so things can fall outside of it or never get put in there that you really have to make sure gets addressed. And so having those regular meetings with your estate planning attorney is important. I don't think you should just create it and be done with it. Even if you have a wonderful advisor or someone looking out for you, it's really making sure that you reconnect with that estate planning attorney, that quarterback, to ensure that things are set up. I want to go back to one thing you said. It was Terrence at 18 playing football, running around Ann Arbor. It's, kids are back in school. Without me kind of tossing it too far down the field to you, tell me what you think the number one concern should be for a parent sending their, 18-year-old child to college, from an estate planning perspective, not from a parent, because what your parent number one concern might look different than you.
Yeah, so that's right.
So as
That's right.
a planning attorney, what would you say would be the number one consideration parents should have when they're sending their child off to school?
So I'm going to scare all the parents just for a second because that question is extremely important. So we go off to college. I remember I went off to college and I'm free for the first time. And my frontal lobe wasn't fully developed. And so I would make decisions that today I probably wouldn't make, right? Probably wouldn't make. And so let's say that I got into a situation where I had a health challenge, eh, doing whatever I was doing on campus. And let's say somehow I ended up incapacitated. And I know that's tough and I know that's scary, but I promised I would be scaring you all. And it's not just to scare you, it's to highlight what I'm going to say in response. And so maybe somebody calls you to let you know that your child is in the hospital. And I say maybe on purpose, because now that they're 18,
They
you
don't
don't
have to.
have an, you don't have to, there's no reason why you had to be notified. And then you call the hospital and they won't give you any information because that child is an adult now. And so you learn and realize pretty quickly that you can't get any information. And so, alternative world, same scenario, same scary situation occurs. And hopefully, none of this ever happens to any of the children of people watching this right now. But you have a healthcare power of attorney in place that you had that child sign on his or her 18th birthday, like my kids do. That's one of the birthday presents they get is a healthcare and a financial power of attorney. They sign it immediately. I don't care who they appoint. They don't have to appoint me,
Sure.
but they got to appoint somebody. And so, same scenario, and you call, you find out, and you call the hospital, and they say they can't talk to you, and you fax over, if you haven't already provided it to the local health services, and your name is listed as their patient advocate, immediately you have access. They've signed a HIPAA release that's on file as well. You immediately have access. And so, what's the most important thing to me for a parent to consider as their child is headed off to school? Please make sure 30 days don't pass from you watching this video and you have not contacted some estate planning attorney. It does not have to be me. but make sure it's a true estate planning attorney, to create a healthcare power of attorney. The real name is a patient advocate designation and healthcare declaration, a general durable power of attorney, so you can help access and manage the financial side of their world if necessary. Then, of course, a HIPAA release. 18 and up, regardless of assets, everyone needs those. And parents, you need to make sure your child has that in place.
Thank you so much, Terrence. I truly appreciate the time that we spent today, the education that you're giving, not just to our audience, but truly to the community. Check out TGQ Law's website for upcoming events. They are everywhere all the time, doing things to help ensure that people understand their rights, the information behind what estate planning truly means. Thank you for being an advocate for our clients, for the firm. I appreciate your friendship. I appreciate all that you offer to those that we serve. And thank you again for your time, Terrence.
Pleasure. Thank you and keep doing a great job. I love what you're doing.
Thank you, sir.